Welcome to Part 2 of the Cedalius Group series on the Fair Credit Reporting Act, Teamwork in Employment Background Screening. In the introduction, we learned that background screening under the FCRA has many moving parts and that compliant background screening requires the teamwork and cooperation of the applicant, the employer, and the Consumer Reporting Agency, or CRA. But before we get to all of that, just what is the FCRA exactly? I'm glad you asked. That question takes us all the way back to 1899 and to the first major credit reporting agency, Retail Credit Company, in Atlanta, Georgia, better known now as Equifax. The company grew quickly, reporting on customers' health, habits, morals, and finances for insurance and employment purposes. In the late 1960s and early 70s, retail credit began to draw criticism and questions regarding the accuracy and legitimacy of its information, and it was even rumored that employees who found negative information were rewarded by management. Eventually, the matter was heard in a congressional hearing, and as a result, the Fair Credit Reporting Act became effective on April 25, 1971. Now, before we go any further, why don't we define some of the key terms you will hear during the rest of this series? Consumer. Put simply, a consumer is an individual. Consumer Reporting Agency, or CRA. This is a person or business who assembles and evaluates consumer reports for third parties. For example, the Cedalius Group is an excellent CRA. TransUnion, Equifax, and Experian are also CRAs. Consumer report is a written or oral communication containing information regarding a consumer's creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, and/or mode of living. Examples of a consumer report would include, but are not limited to, criminal and civil records, credit reports, and driving records. Investigative consumer report is a report based on personal interviews with neighbors, friends, or colleagues. These reports contain more detailed and subjective information than a standard consumer report. Reference checks completed by a background screening provider, for example, are considered investigative consumer reports. Permissible purpose. Under Section 604 of the FCRA, consumer reports can only be furnished for the following reasons: court order or subpoena, per the consumer's written instruction, credit transactions involving the consumer, employment purposes, insurance underwriting, license or government benefit eligibility, assessment of credit or prepayment risks, or a business transaction initiated by the consumer. Person is any individual, partnership, corporation, trust, estate, cooperative, association, government or governmental subdivision or agency, or other entity. And lastly, furnisher, which is a source providing the consumer report information to a consumer reporting agency. Still with me? Great! Let's learn some more history about the FCRA. The FCRA was originally intended to function primarily for credit issues, but the language was written in such a vague manner that background checks fell under the FCRA as well. To tighten up some of the ambiguity, there have been several major amendments to the FCRA that have shaped the law as we know it today. In 1996, changes were made to the FCRA via the Consumer Credit Reporting Reform Act to allow organizations to share information in credit reports and to provide for a limited preemption of stronger state laws on credit. In 2003, Congress enacted the Fair and Accurate Credit Transactions Act, which in part allows consumers to obtain a free credit report every year. In 2010, the newly created Consumer Financial Protection Bureau, or CFPB, began sharing responsibility with the Federal Trade Commission to enforce the FCRA. And just recently, in 2015, the CFPB cracked down on two major background screening providers for failing to take reasonable measures to ensure the accuracy and security of the information they provide. Together, the two CRAs paid $13 million in restitution and penalties. There you have it. The FCRA hasn't yet reached its 50-year anniversary, but it has undergone several overhauls in order to strengthen and clarify its place especially in reference to background checks. So now that we understand the FCRA a bit better, we can talk about how it impacts the consumer, the employer, and the consumer reporting agencies, as all parties involved in the background screening process are governed to some degree by the FCRA. Please join us next time as we delve into the employer's obligations and the applicant's rights under the FCRA. Until then, we are the Cedalius Group, the employment background screening provider you can trust.